So I have an important update in the suppressor freedom lawsuit, which aims to remove a state ban on the purchase and possession of suppressors. So let's talk about what is happening. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm's an amazing company. They have amazing supplements if you're trying to get healthier and work out more, but also they're pro-freedom, pro-America, and they support the Second Amendment. So if you're interested, check out 1st Phorm using the link down below. And if you order something $50 or more, you can get a free 4-pack of energy drinks. As I mentioned in the intro, in this video, I have an important update in a lawsuit which aims to remove statewide bans on the purchase and possession of suppressors. The case we're going to be talking about in this video is called Morris versus Raoul. This lawsuit is filed in a federal district court in Illinois, and it aims to remove the state of Illinois' ban on the purchase and possession of suppressors. This lawsuit could be the first in the nation which actually finds that a state cannot outright ban NFA items like suppressors, and to do so is unconstitutional. This also could have major implications for other statewide bans on the possession of SBRs and other NFA items like suppressors. Currently in this case, the state of Illinois is trying to have the case completely thrown out by arguing that suppressors are not arms and therefore not protected by the Second Amendment. The state of Illinois is currently requesting that the judge in this case grant a judgment on the pleadings and essentially rule in their favor early and throw the case out. This case was temporarily put on hold, but now the state of Illinois has asked the court here to take notice of a new case. The 5th Circuit recently issued a decision which held that suppressors are not arms within the meaning of the Second Amendment, and that suppressors are not needed for the function of a firearm. Now, in this Illinois case, the plaintiffs argued that suppressors are not dangerous and unusual items, and that the mere ownership of suppressors cannot constitute the ownership of a dangerous and unusual item. Instead, these are common arms owned by law-abiding people for lawful purposes. The state of Illinois recently filed a motion for a judgment on the pleadings, and essentially they're trying to get the case thrown out early and really before the case even begins. The entire motion is based on the state's argument that this case should be thrown out because suppressors are not protected arms under the Second Amendment. In the state of Illinois' motion, they argue that the Second Amendment protects only the right of the people to keep and bear arms. Silencers are not weapons. They are not useful for self-defense, and they are not necessary for the effective use of a firearm. So they are not arms within the meaning of the constitutional text, and thus plaintiffs cannot prevail on their Second Amendment claim. They go on to argue in this motion that while an instrument need not have existed at the time of the founding to fall within the amendment's ambit, it still must fit the founding era definition of an arm. But a silencer is not itself used to cast at or strike another. It does not contain, feed, or project ammunition, and it does not serve any intrinsic self-defense purpose. And while some people find silencers useful, they're not so critical to firearms ownership that firearms cannot be used effectively without them. They argue silencers are therefore not arms within the original meaning of the constitutional text. They also state that silencers do not satisfy this definition of arms. A silencer is a firearm accessory, it's not a weapon itself. So the state's primary argument in this lawsuit is that a suppressor cannot be considered an arm under the Second Amendment because it is not an actual firearm, it doesn't shoot a projectile, and it is not absolutely necessary for the function of a firearm. They believe that at the very least, a suppressor is simply an accessory and can be regulated therefore because it's not protected. Now, this case was recently stayed, and the decision on the motion for judgment on the pleadings was also stayed by the judge here because he believed that the Illinois rifle ban decisions, which were pending, which dealt with PICA, the Protect Illinois Communities Act, that decision there could impact this suppressor case. The judge in this suppressor case wanted to see maybe how another lower court applied the 7th Circuit's recent decisions on rifle bans. Also, keep in mind within PICA, there are restrictions on various characteristics and accessories like flash suppressors, threaded barrels, and other potential accessories and characteristics that could impact this lawsuit. Recently, Judge McGlynn in the PICA case issued a decision striking down PICA as unconstitutional, and because of that, the plaintiffs in the suppressor case have submitted that win as support for why the motion for judgment on the pleadings should be denied and why the suppressor ban should also be struck down. Now, in response to that, the state of Illinois has now submitted their own supplemental notice to the court here, and they've actually pointed to a new case out of the 5th Circuit in a case called U.S. versus Peterson. The Peterson case involves an individual who had a gun store that was raided by the ATF, And during this raid, the ATF found a single solvent trap that was not registered or serialized. And because of that one item, Mr. Peterson was charged with violating the NFA and was charged criminally. Mr. Peterson and his attorney tried to get that charge thrown out by using a motion to dismiss by arguing that the NFA is unconstitutional under the Second Amendment. The district court denied that motion, finding that silencers are not bearable arms protected by the Second Amendment. That decision was then reviewed by the Fifth Circuit in a 3-judge panel, and ultimately they found that suppressors are not arms because they do not trigger two-way protections. The main thrust of that decision by the Fifth Circuit was they believed that these are not arms, that they are not, armors of defense or arms of offense, that they are not used to cast at or strike someone. And so they found that these are not absolutely necessary for the function of a firearm. That decision is likely going to be reheard by the Fifth Circuit en banc panel, but the state of Illinois is trying to use that decision as support for why their suppressor restrictions within the state do not violate the Second Amendment. So in this new notice of Illinois to the court here, they state that Peterson holds that suppressors do not trigger Second Amendment protections, thus rejecting the same theory passed by the plaintiffs here in this case in the consolidated actions. As the Fifth Circuit explains, whether suppressors constitute arms is an issue of the first impression of our circuit. And so far as we can tell, every court to have addressed it has decided the question in the negative. A suppressor by itself is not a weapon. Without being attached to a firearm, it would not be of much use for self-defense. Instead, we agree with the 10th Circuit that a suppressor is a firearm accessory, not a weapon. And while possession of firearms themselves is covered by the plain text of the Second Amendment, possession of a firearm accessory is not. As the government aptly explains, an operable firearm will work perfectly well without a suppressor, but a suppressor would not transform an inoperable firearm into an operable one. Moreover, it can hardly be said that suppressor regulations have rendered the right to keep and bear arms meaningless. The use of a suppressor, as we noted above, is not necessary to the use of a firearm, so it is not protected by the plain text of the Second Amendment. So that was the Fifth Circuit decision on a similar suppressor case that is now being used in this Illinois suppressor challenge. The court has allowed that additional supplemental case to be presented in the Illinois lawsuit as further evidence, and they will consider it for the purposes of the judgment on the pleadings. Recently, this suppressor case in Illinois went to a status conference, and as a result of that conference, the case was put on a temporary hold, and they're waiting to see what happens and what develops in the PICA challenge. Despite that, other decisions by the recent Fifth Circuit and recently also one out of the Fourth Circuit have been used and are leaking into this challenge in Illinois. That is why decisions like that one out of the Fifth Circuit in the Peterson case are really concerning, because we always know that they're going to use those lawsuits in other cases and in other jurisdictions to support similar types of bans that are being litigated. So we talked about the Peterson case in the past, but now that challenge and that decision out of the Fifth Circuit is being used in Illinois, and Illinois is trying to use that to uphold their statewide ban on suppressors. So this is something we're going to be watching closely, because we want to see what impacts and what broader implications that Fifth Circuit decision will have. I have no doubt that in some ways it's going to impact the Illinois suppressor challenge. Right now, that case is temporarily on hold, but we're going to see how that develops. Also, keep in mind, like I mentioned, even that case in the Peterson lawsuit, that is likely going to be reheard by the Fifth Circuit en banc panel. So we're going to see how that develops as well. So as we get more information, as things develop, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.